How to get a high grade in contract law. This is what you need to do. First of all, you need to analyze your exam requirements. You have to do selective studying, practice answering problem and essay questions, and make sure you follow professor's guidelines. So what does it mean? You have to download past exam papers. In the past exam papers, you will see very clearly what kind of questions come up, which topics come up, and then choose the topics that you like the most, you understand the most. Also, the amount of topics should be selected according to how many questions you have to answer on the exam. For example, if you have to answer 2 questions on the exam, maybe you select 2 topics or 3 to have one as a backup. I usually advise students to have at least one topic as a backup, because you may not get the question you were expected. So you were expecting. So you should have one question as a backup. Also, bear in mind that some topics may be mixed. For example, misrepresentation and exclusion clauses usually come together in the same question. Also, offer acceptance, consideration, intention to create legal relation can come up as one big problem question about formation of contracts. So according to the past exam papers, make sure that you are able to answer the right amount of questions, depending on how many questions you are asked to answer on the exam. And make sure you follow professor's guidelines. This may differ from one professor to the other. So some professors like it in a specific order or specific structure. So make sure you read all the guidelines on the platform, on your university's platform, whatever they are using, Moodle or Canvas, and follow the guidance. Key topics to revise: offer, acceptance, consideration, intention to create legal relations, misrepresentation, exclusion clauses, and promissory estoppel. How is the contract created? First of all, you should understand how the contract works. The contract is a combination of these elements. First of all, there has to be a valid offer. After, there has to be a valid acceptance, followed by a consideration and intention to create legal relations. These 4 elements makes up a valid contract. What is an offer? Offer is a clear and equivocal statement that will be regarded as legally binding. On the other hand, there is invitation to treat, which is simply an invitation to make offers. For example, when you see a display of goods in a shop or in a supermarket, that's not an offer, that's an invitation to treat. In a problem question, you will most likely be asked to differentiate what's the difference between the offer and an acceptance and provide critical analysis on the facts of the case. Do you have an offer or do you have an invitation to treat? You have to provide analysis by reference to the relevant cases. So you have to cite the relevant cases about invitation to treat, relevant cases about offer, and then conclude what is the most likely outcome. Is it going to be an offer? Is it going to be an invitation to treat? In law, you don't have clear-cut yes or no answers. Usually there is a discussion, there is critical analysis, there are more likely outcomes, less likely outcomes, but there is no clear-cut yes or no answer. Acceptance. What is an acceptance? Acceptance is an unqualified expression of assent to the terms proposed by the offeror. An offer on its own does not lead to contractual liability. So when one party makes an offer, just the offer is not enough to create a contract. It must be followed by an acceptance. Offer can be revoked, but only before the acceptance is made. For all the statements in a problem question or an exam, you have to cite relevant authorities. You cannot just say things without citing relevant cases. In contract law, you don't have that many statutes. So most likely, especially about offer and acceptance, it's just cases. And make sure you remember the cases for these basic principles, like for definition of acceptance or for the rule that offer can be revoked before acceptance. Make sure you have a list of all these cases. Consideration. Consideration is mandatory. Without consideration, contract does not exist. Free promises are not enforceable in English law. So once there is offer and acceptance, do not just straight away conclude that there is a contract, because it must be followed by consideration and there must be intention to create legal relations. Past consideration is not good consideration. Consideration is usually something that is given in exchange of the promise. It's usually money, but it does not have to be money. For example, when you buy something on Amazon, when you go to the website, that's invitation to trade, because those are products displayed. Display of products is usually invitation to trade. Once you select the product that you want to buy, you're making an offer. And then they accept it, and finally you make a payment. That payment is consideration. That's the exchange of value. And finally, there is intention to create legal relations. Usually in business settings, the presumption is that you intend to create legal relations. Whereas in family settings, like when you are dealing with family members, the presumption is that there was no intention to create legal relations, but these presumptions can be rebutted. But we'll talk about it in more detail when we are on the side of intention to create legal relations. You should consider that if consideration was created in the past before the offer and acceptance, that won't be good, because past consideration is not good consideration, as it was established in the case of Re Mercado. Consideration must be sufficient, but does not need to be adequate. So even just £1 could be a good consideration. It does not have to be the market value. So you could, in theory, buy a huge property that is worth a lot of money for just £1 could be a good consideration, because you don't have to purchase products on its market value for the contract to be valid. For the purposes of consideration, as little as £1 would be enough. In Chapel case, 3 chocolate bars were a good consideration. So as you can see, it does not have to be even economic value, just something that has some kind of value. It doesn't have to be money. Intention to create legal relations. This one is all about whether or not we are dealing with a domestic agreement or a commercial agreement. If it's a domestic agreement, presumption is that there are no intention to create legal relations, but this can be rebutted. In law, there is no clear-cut answer. So there are rules, but usually those rules always have exceptions. The same thing with this. If it's a domestic agreement, yes, the first thing you should consider is that there is no intention to create legal relations, but this can be rebutted. So it all depends on the facts of the case, and you have to provide a critical analysis by reference to the case law. Commercial agreements, strong presumption that parties intend to create legal relations when we are talking about business. See cases of Arrington and Balfour. On Simple Selling platform, we have case summaries of most of the cases that are taught on undergraduate law degrees. So make sure you check it out. Misrepresentation. Misrepresentation is one more very important topic you should know for a contract law exam. Most likely it will come up on your exam, and it is usually mixed with exclusion clauses. So you will have to revise both together. Ambiguous false statement of fact or law addressed to the party misled, which is material and which induces the contract. That's the definition of what is a statement that can lead to misrepresentation. So it has to be statement of fact or law. And it has to be addressed to the party misled. It can be through direct communication or from a third party. There are three types of misrepresentation. So the first thing you need to do in the problem question is you have to establish whether or not these requirements are satisfied. So is it a full statement of fact or law? Is it addressed to the party misled? Or is it material and does it induce the contract? Was it a significant reason why the contract was created? If it was not for this statement, would the party have still entered to the contract? After you establish that it was a statement of existing fact or law and not a mere path, then you can refer to three types of misrepresentation and discuss which one is it. There is fraudulent, negligent, and innocent misrepresentation. You should discuss each one of them and provide critical analysis to explain which one is more relevant for the problem question that you are dealing with. For fraudulent, it's quite hard to prove. It requires proof of fraud, and the threshold for proving fraud is very high. It's set out in the case of Deek. The alternative is to prove negligent misrepresentation, which is the more viable option. So if you can also advise in the problem question which claim is more viable, that can lead to first class. So that shows that you not only understand what is misrepresentation, but you have so deep of an understanding of misrepresentation that you can even advise which one is more viable claim and which one isn't. So make sure that you say about fraudulent that it's less viable because it requires proof of fraud, and the threshold for proving that is very high. Negligent misrepresentation is usually the more viable one because Misrepresentation Act, Section 2, 1967, is easier to prove. It does not require special relationship test like it is the case for Hadley-Burn. There are two kinds of negligent misrepresentation. There is a negligent misstatement and there is negligent misrepresentation. You should be able to understand what is the difference between the two. Both are negligent and both are misrepresentation, but what's the difference? The first one is the one at common law and is assessed through Hadley-Burn test, the special relationship test. The second one is the statutory one, is from Section 2 of the Misrepresentation Act, 1967. The statutory one is usually more viable one because it does not require special relationship test, and proving pure economic loss through Hadley-Burn principle is really hard. Usually, this claim usually fails. So you should advise in the problem question the parties that statutory negligent misrepresentation is more viable option. Another one is innocent misrepresentation, but the problem with this is that the damages you can recover from innocent misrepresentation is lower than from negligent misrepresentation. So in the problem question, if you write all of that, the damages are lower for innocent, and you advise the party to prove the negligent misrepresentation instead to get higher damages, that shows better understanding of the law, and it could lead you to higher grade. And finally, talk about remedies. What are remedies available? It could be damages, most likely. That's usually the most common remedy that you can claim for misrepresentation. But there could be also a termination of contract. So one of the remedies would be to terminate the contract. What is exclusion clause, or otherwise called exemption clause? It's a clause in the contract that is supposed to exclude or limit liability. Exclusion clause must be validly incorporated in the contract by signature, notice, or previous course of dealing. The first thing you will have to do is to discuss whether or not exclusion clause was incorporated in the contract and which method was used. Was it incorporated by signature? Was there a contract where it was written and the contract was signed? Was it by notice? Was it by previous course of dealing? Usually when it's an unusual term, it should be both signature and notice. For example, when you go to Simple Selling Platform, in our terms and conditions, it says that when you get a subscription, it's subject to recurring payments. So it's already there in the terms and conditions, but we also make a notice of that on the registration page, just to give extra attention to that. And it's not really an unusual term because a lot of subscription services do that, but we still draw an attention to this because it's an important one. So it can be both. It can be included in the contract as well as notice. And the law says that it should be drawn, the attention of the party must be drawn to any unusual term or an important term outside of the contract. And liability cannot be excluded for death or personal injury as a result of negligence. If exclusion clause excludes liability for negligence or breach of contract, it must go through the reasonableness test. And that was written in Section 111 of Unfair Contract Terms Act. Section 2 is about negligence. Section 3 is about breach of contract. And both sections say that if they try to exclude liability for negligence or breach of contract, it must pass the reasonableness test. If it's unreasonable, then it will be excluded. Finally, you should revise promissory estoppel. This is an equity principle and flexible way of achieving justice. In what kind of circumstances does promissory estoppel come in? So imagine you have a contract, but there is no consideration because there is no exchange of anything in value. If consideration fails in certain circumstances, promissory estoppel can save the contract. Promissory estoppel can still enforce the contract, even in the absence of consideration. But it has to be done in certain, it can only be used as a shield, not a sword. So it cannot be used to create a new action. It can only be a defense. The requirements are that there must be an existing contract between the parties. There was a clear promise that was intended to be acted upon. There was clear reliance and detriment. If these four requirements are met, only in that case, promissory estoppel can apply. Finally, I'd like to show you that if you go to our platform and look up contract law, we have revision notes, case summaries, model essays, quizzes, tutorial videos, and flashcards. All you need for getting a high grade on contract law. But this doesn't mean that you should not be looking at your lectures. We advise for best results, look at the lectures as well as our notes. Our notes can be used instead of books. So you don't have to be reading books if you're reading our notes, if you're reading our materials, but you still should look at your lectures because your lectures contain very important information of what your professor expects from you. For example, which cases do they want you to mention on the exam? Do they want you to emphasize on the exam? What kind of structure do they want you to follow? It's impossible to know without looking at the lectures. So make sure you look at the lectures. You can get our materials for only £35 and you will have access to it forever, or you can get a subscription that gives you access to all the study materials we have for all main areas of law. In addition, we strongly recommend you to get tutoring sessions, one-to-one tutoring sessions, and the tutor will help you prepare for your exam. Now a little bit about how we can help you. We are a group of successful law graduates. We have achieved Priority 1 and first class in our degrees. We come from different English universities. we are not associated with universities, but we hire their best graduates. We provide educational support services for law students to help you get a first-class law degree. We help with tutoring sessions. We teach how to correctly prepare for your exams, how to write courseworks, even dissertations, and we help you get high grades. We help you understand how to write legal essays, give you guidelines for exams and courseworks. So make sure you book your tutoring session as soon as possible because demand is very, very high for this service because of the upcoming exams. We have over 100 reviews already and 25,000 subscribers that are studying on our platform regularly. So join our team and you can now study with us to get a first-class law degree.